I can't hear you. I don't know if others can.
Oh, sorry, I was muted. My bad. My
That's
apologies.
okay.
No, I just wanted to thank you for partnering with us to offer this information. We've been looking forward to it, and yeah, so just thank you so much, and thank you for everyone that took the time today to jump on. And I'm sure it will be very useful information that we all could use to help ourselves and help our residents and family members, kind of navigate through healthcare. So thank you so much.
Thank you. And thank you so much for doing this with us. We really appreciate it and look forward to future events. So I'm going to go ahead. I'm Jessica Green. I'm a certified elder law attorney with Walters and Galloway, and I am going to share my screen. I have a little PowerPoint that I put together here. All right. So as we go through this, if anyone does have any questions, feel free to, interrupt me, go ahead with any of those questions. But otherwise, I have, quite a few slides here tailored to just kind of getting through the long-term care system. And I do have my contact information on this first screen. So if anyone wants to reach out to me after, you have our information there. So the first thing that everyone should be considering when we're trying to deal with long-term care is we first need to look at what type of estate plan someone has in place. We want to first look at, do they have what we call the foundational documents? So it'd be a last will and testament, a durable financial power of attorney, a healthcare power of attorney, and a living will. First off, with the last will and testament, everyone really should have this document. This document is used to allow someone to designate who they want to receive their property after they pass away. So we call those people their beneficiaries. Now you can put certain restrictions on the types of property that you're leaving to someone. If you want to leave it in trust or you want to have it held for a certain period of time, you can do all of that in the last will and testament. This document will also allow you to choose someone who will be in charge of settling your affairs. This person, we like to think of them as, we call them the executor or executrix or personal representative. You can also appoint a guardian for any minor children in the will and a trustee for any funds that will be held in trust. So if you have an underage beneficiary or you have someone who may have a disability and you don't want them to lose their government benefits, you can put trusts in your will to help avoid that. Typically, people have what we call an I love you will. So this is kind of a funny name. So I love you to my spouse, and that means my spouse gets everything. And then when we both have passed, it all goes to our next round of beneficiaries, whether those are children or, other family members, or maybe it's our favorite charity. It's very simple, straightforward, not a lot of complexities in there. These types of wills can be great for people who really, all they need is something very simple. They don't have anything complicated going on. But the issue is that as we age and our circumstances change, we really need to take a look back, not only at the will, but at all of the documents. Make sure that we're updating when we need to. So that takes us to, a more complex will. So if you have a situation, let's say we have husband and wife, and husband is in the nursing home and then husband gets on Medicaid or medical assistance, which we'll talk about a little bit later. If wife would then pass away and have what we call an I love you will, which means everything will just go to husband, then husband will inherit everything from wife, and husband will then lose his Medicaid, his government benefits. So once someone enters into that nursing home type of situation, we really should be updating from the I love you will to a more complex will that's probably going to have a testamentary trust in it. So that's a trust that's in the last will and testament and is only created for a specific purpose at a specific time. So wife's will hopefully was updated to say, if my husband is in the nursing home, or he's what we consider a supplemental needs person, he's getting some sort of government benefit, I don't want to leave everything directly to him. I'm only going to leave him what I have to under Pennsylvania law, and then the rest will go into a trust for him to make sure he doesn't lose his government benefits. So you can do that kind of thing. And that's why it's so important to have these documents evaluated, especially when you have a change and you're trying to deal with the long-term care system. So changing your will to have language like that will help with navigating the long-term care system. So we typically say you want to update your will upon the 4Ds. So if there's a divorce, a death in the family, a new disease or diagnosis, and then every decade. But some people really should have them looked at more than every 10 years, but that's kind of like a maximum that you kind of want to look at. Next, I want to think about the financial power of attorney. So the last will and testament, the key with that is that it's only going to be looked at after you passed away. So that's when it becomes irrevocable. You can't change it anymore. Whereas the power of attorney is actually only valid while the principal, the person who created the power of attorney, is alive. So when the principal passes away, the agent cannot act for that person anymore, and the power of attorney stops working. So in the power of attorney, it used to be years ago, we called it a general power of attorney. So we had financial decisions, legal decisions, and medical all in one document. Sometimes it was really just one page. It was the longest run-on sentence you might have ever seen. And it just kind of went on and on and on about everything the agent could do. And then they signed at the end, and that was it. But now we really have to be much more specific about the powers that we're giving our agent. So the agent is the person that has been chosen in the power of attorney document to make the financial and legal decisions for the creator of the document, the principal. Now, there are various types of powers of attorney. There could be one, we call it like a limited power of attorney. So it's limited to a certain item or a certain aspect. So, it might be, maybe you want to sell your house, but you live in Florida and the real estate is in Pennsylvania. You can appoint someone through a limited power of attorney to be able to sign to sell your real estate. You might have a power of attorney that's what we call a springing power of attorney. So it only springs into effect upon a certain thing occurring, like you become incapacitated. Now, those are not as common now as they used to be. Most powers of attorney really are going to be effective immediately. And you want to do that so that you do not have any delay in your agent being able to help you if something would occur where you couldn't help yourself, couldn't pay your bills, make your legal decisions, all those types of things. Now, if you're looking at it from a long-term care point of view and how to navigate this system, then we want to have very specific powers. We call them hot powers in the financial power of attorney. So I have some examples here with the law changes in 2015, 2016, and then there were even some last year. It's really important to make sure that you're updating this document pretty regularly, having an attorney look at it. But not only are you having an attorney look at it, you want to make sure that person does specialize in long-term care issues. You want to make sure you're seeing an elder law attorney so that the right language is in there. For example, I have unlimited gifts here. If your power of attorney does not give your agent the right to make unlimited gifts, then if you end up in a nursing home one day, your agent will not be able to protect your assets from the cost of that care, even if your agent is your spouse. So your agent will have access to any jointly owned accounts, but they won't, for example, be able to, cash in your IRA or something that's in your name alone that we might otherwise want to protect, but not be able to unless the right language is in this document. Another issue that comes up is with jointly owned accounts. So let's say you have an account in your name alone, but you want to add your spouse or your child as a joint owner. You have to have that specific power listed in the power of attorney document. Otherwise, your agent will not be able to add or remove someone on a jointly owned account. Sometimes it can be very important for an agent to change beneficiary designations. So let's go back to my example earlier that I brought up with the will. So husband's in the nursing home, wife is at home. Let's say wife is his agent and she's trying to transfer things and protect it from the cost of his care so that she can still live at home and maintain and do everything that she needs to. If husband has, let's say he had an IRA and he never put a beneficiary on it. If the right to change beneficiary designations is in his power of attorney, then wife can go in and change that to herself, for example. So that's just, a little something that could be helpful. We want to make sure we're giving kind of those broad powers to the agent to be able to protect the assets from the cost of the care. If there is no power of attorney in place, and someone has already lost capacity, so they don't have the ability to create these documents, then that person's loved ones will have to go to court, call it guardianship, and petition the court to get appointed to act as their guardian, to be able to make their decisions for them. Then not only with that, they'll have to do a yearly accounting and check in with the court and get court approval to really do anything. So it's just really important to make sure that we have this document in place ahead of time so we don't have to deal with the courts on any of these issues. Next, we want to talk about the healthcare power of attorney and living will. These are actually two separate documents, but under Pennsylvania law, they allow us to combine them into one form just for simplicity purposes. So that's kind of why I combine them here. I'm talking about them. But the healthcare power of attorney is the document that's looked at if you're unable to make a healthcare decision for yourself. It does not have to be a permanent situation. Let's say you're driving, you get in a car accident, and you're knocked unconscious. Your healthcare agent can authorize any surgeries, any medical treatment that you might need. And then when you wake up, you're good to make your decisions again, and your healthcare agent wouldn't continue to act for you. So it's really, if there's an emergency that happens, your healthcare agent can authorize the treatment, but it's not something that has to be permanent. Whereas in the living will, that is only looked at if you are permanently unconscious or you're at the end stage of a terminal medical condition. So you can see how you would make very different decisions between the healthcare power of attorney and the living will. In the healthcare power of attorney, you're probably authorizing your agent to give you any types of procedures or surgeries, anything that might be needed to get you better. Whereas in the living will, you might be giving different decisions or directions, like we say for end of life. So if you are at that end of life or you're permanently unconscious, do you want tube feedings? Do you want life prolonging procedures? These are the decisions you would be making in that document. Now, the healthcare power of attorney and living will, the law that controls that was changed back in 2018, and it heavily focused on organ donation. So if you are an organ donator, you really should update this document and take a look at what you have to make sure that it accurately reflects what your wishes are. Because what they've done is they've separated out traditional organ donation from like your limbs, facial tissue, vascularized composite allografts. Those are kind of extra things. So if you want to donate everything, then you want to make sure that you specify that in your healthcare power of attorney and living will. It's also really important to note that you want to have the HIPAA waiver in your healthcare power of attorney. That way your agent can see your medical records and speak with your doctor to help you make an informed medical decision. Now we're going to switch gears a little bit here, but before I get into Medicare, did anyone have any questions about the estate planning documents?
Jessica, this is Trevor. I just have one question. So, with the couples, you talked a lot about the spousal. You said under PA law, there's a certain requirement of monies that have to be designated to the spouse. What is that requirement?
Right, so in the Probate Estates and Fiduciaries Code, which is the Pennsylvania code that controls, wills, powers of attorney, all these types of documents, it says in there that a spouse is entitled to what's called their elective share, which is effectively 1/3 of the estate, but they get credited for anything that they already were a joint owner on or anything they were a beneficiary of. So going back to my husband and wife example, if husband is in the nursing home and on Medicaid and the wife passes away, if the wife completely cut the husband out of her will, he would have to take actual court action to make his elective share, because if he didn't, Medicaid would kick him off of his benefits. So he's legally required to take that. So what I typically do is I'll just leave the person the 1/3 that we have to, and then the other 2/3 we can shelter.
Okay. And how does so all of this? I mean, I understand that if one of the spouses is under Medicaid and under a skilled, requiring skilled care, but what about the instance here of like ecumenical where we're personal care? Because we sometimes have, one spouse that comes to us, and the other one is at home. How is all of this applicable to them, or is it some of these laws? And
right, because, so the documents that I went over, definitely everyone should have them, whether we're dealing with skilled nursing or personal care. The elective share, that's something under Pennsylvania law that all spouses are entitled to, but really only a spouse who is on Medicaid is going to be required to take that. So I know in personal care, they can't get Medicaid. So really, we're just going to have to keep paying until either the person passes or they move to skilled nursing. So it's a bit different. But certainly, having this language in the documents is really helpful either way.
Okay. All right. Thank you.
Sure. All right. So I'm going to talk about Medicare a little bit. It's really upsetting for a lot of people when they realize that Medicare is not going to pay for their long-term care. I don't know how many people on this meeting today, and you don't need to raise your hand or say who you are, have long-term care insurance, but that, obviously will help with home care, personal care, long-term care in a nursing home. But Medicare will only pay up to 100 days if you're going to a skilled nursing facility after you had 3 consecutive days where you were admitted to the hospital. So it has to be that you were actually admitted and then considered an inpatient, which means then your Medicare Part A would cover that. And like I said, up to 100 days at the nursing home after the hospital stay. But it's only going to cover 20 days at 100%. And then after the 20 days, there's a daily copay. It's around 180 some dollars a day. And then typically, Medicare will not pay the full 100 days. So at some point, they'll do an analysis and determine if it's still medically necessary for the person. And if they determine it's not, then Medicare will stop paying. So who starts paying after the 100 days? Anybody know? No takers? All right, so it becomes private pay. So you have to pay out of your own pocket at that point. Or you can try to apply for Medicaid, or medical assistance is what we call it in Pennsylvania. So some basic qualifications I have here. So first off, the person has to qualify medically. So they have to meet all the requirements. They have to be what we call nursing facility clinically eligible. So a doctor has to certify that. So once you get through the medical requirement, then they're going to look at the person's income. So typically the income requirement is met pretty easily, because most of the time people do not have, $10,000 a month in income in retirement. So the way it works is they only look at the person who is in the nursing home's income. They do not look at the family income or the couple's income. So in my example earlier, when I said husband was in the nursing home, they would only look at husband's income. So it'd be like Social Security, his pension, but they would not look at any of wife's income to qualify for Medicaid. So as long as his monthly income is less than the cost of care each month, then he'll meet the income requirement. Then they're going to look at the assets. So what they do is, for this, they have another income requirement that they look at. So if someone's income is less than $2,382 a month, then they'll be allowed to keep $8,000. If their income is greater than the $2,382, they're only allowed to keep $2,400. Now, if the person is married, they still only get to keep the $2,400 or the $8,000, but their spouse gets to keep half of the assets up to a maximum of $130,380 as the number that was just updated in January of this year. So if my husband and wife in my example have $200,000 in countable assets, the wife will only get to keep $100,000. She will not get to keep the full $130,000. If the couple has $300,000, the wife will only get to keep $130,000, $380,000, not $150,000. Just so everybody kind of understands that. So we're going to talk a little bit about what's protected. So when you're dealing with Medicaid, medical assistance, there are some things that are protected from being used or forced to be cashed in to pay for skilled nursing. So, to pay for that care. So Medicaid will not force someone to cash in their primary residence as long as the equity is $603,000 or lower. It will not be considered as a countable asset to pay for care. So when we're dealing with this type of situation, we have the institutionalized spouse. That's the person who's in the facility. And then we have the community spouse. So the community spouse is the person who is not in the facility. And we're just talking about, for this purpose, it would be a skilled nursing facility, not personal care, like ecumenical, like Trevor was talking about. For ecumenical with being personal care, long-term care insurance is extremely helpful to pay for personal care. Veterans benefits is also very helpful if you're a surviving spouse of a veteran or a dependent of a veteran or a veteran themselves, then those benefits can help pay for personal care as well. But going back to the protected items here, so the community spouse's IRA, their retirement account, so a 401k, anything that's kind of that was money that was put aside as their retirement, Roth IRA, those types of things would be protected from that cost of care. Now, the community spouse's monthly income would also be protected. Any household goods or personal effects, any income producing property. So if they own, rental property, but they rely on that rent for their living, then that would also be exempt. Anything that's an irrevocable burial reserve or account, as long as it's not over the certain amount. Term life insurance, so that's life insurance that does not have a cash value, would not be considered available. And then one motor vehicle. I'm going to talk a little bit about gifting here. So there are a number of different rules when it comes to gifting, and it can get very confusing. So for federal gift tax purposes, you can give $15,000 per person per year, and you will not have to file a gift tax return. So you won't owe any gift tax and you won't have to file a return. Now, for veterans benefits purposes, if you would give anything away within 3 years of applying for the VA benefit for the pension program, the aid and attendance program, then they would disqualify you or penalize you for that program. And then for Medicaid purposes, if you transfer anything for less than fair market value in the 5-year period or 60 months prior to the Medicaid application, then that's also an issue that would create a penalty period. So typically for Medicaid, we say you should not give more than $500 a month away, and that's total, that's not per person. And you cannot add that all up at the end of the year and just give $6,000 in the month of December to one person. It actually has to be monthly. So I actually have some clients who, they wanted to contribute to their grandkids, college educations. So, they wanted to give a certain amount at the end of the year. So say they plan to give, $1,000 to each grandchild at the end of the year. So they actually will start in January and they'll say, okay, grandchild number one gets 500 in January. And then grandchild number one will get 500 in February. Okay, now grandchild number one is done. And then they'll start with grandchild number two in March with the 500. So they'll do that each month until they can get to the amount that they wanted to give away that year, but they have to keep with that 500 a month. Something that people don't realize that they really need to be careful about are cash withdrawals. And I know there are some people who just have always dealt in cash, and that's just what they're used to. They don't like to have a credit card or a debit card or, do online paying, those types of things. But the problem with dealing with cash is that it's extremely difficult to show that you spent that money on something for yourself and did not just give it away to someone. So if you can't prove where all that money went, then Medicaid will assume that you just gave it away to somebody. And now you'll have a gifting issue and a penalty period when you go to apply for medical assistance. So you definitely want to be dealing more in checks or credit cards, something that you can show a money trail. Now, if we end up in a situation where you've given a whole lot of money away and you can't get any of it back, now you're out of money and you're in the nursing home and you're applying for Medicaid. Medicaid will actually look at 5 years of tax returns and bank statements. They are extremely thorough. They will find out that you gave all this money away. And the problem is that typically you won't find out until you've been in the nursing home for quite a few months. So now you've racked up a nursing home bill, and then you find out that you're not going to be able to get Medicaid. So that's where filial responsibility comes in. This is a law. It was actually a really old law, and then they moved it to another section of the code, a few years back. And this says that children are responsible for the care and support of their indigent parents. So through this law, some facilities have been able to sue the children to pay for the parents' unpaid bills. That's why it's so important to make sure that you're not making gifts and doing things that you shouldn't be, because then they will go after your family for those costs. You just really need to be so careful. Those costs need to be paid. So let's just make sure that you don't do any gifts or anything that you're not supposed to do. And then, Medicaid would help you pay. So there are some pre-planning options. Certainly, if you were still of a good age, the long-term care insurance can be a good option, but it can be expensive. So you have to be, very careful about that. There's also a Medicaid asset protection trust. So you can use trust planning not only to help with Medicaid, but also to help with qualifying for veterans benefits. So if you do an asset protection trust and you transfer assets into it at least 3 years before you would apply for the VA benefit, then it can help you qualify much sooner. For Medicaid, you have to have the assets in the trust for 5 years before you would apply for Medicaid to have those assets protected. But there are other allowed transfers. So I have listed some here. Children sometimes fall into a special category of how we can protect some assets. So there are what we call life estate options. And hold on here, getting some feedback. If everyone could mute themselves, that would be really great. Okay. All right. So with the life estate options, this allows for a couple of different scenarios. So let's say that we have, parent and child, and parent has sold their home and they want to go live with their child, and they can actually buy the right to live in their child's home for the rest of their life. So we call it a life estate. So we would do a special kind of deed so that the parent is able to live there for the rest of their life. And as long as the parent has not paid more than fair market value, then this will be perfectly allowed. And as long as the parent lives with the child for at least 1 year before going to a facility, then it will not be considered a gift for less than fair market value. So there are certain factors that we look at to determine how much that life estate is worth and how we can figure out the fair market value for it. Then there are other options. So let's say that parent wanted child to move in with them, but they wanted to transfer the house and reserve a life estate for themselves. There are lots of different options that can go along with that. The caregiver agreement is a great one. So if child had to, it doesn't have to be a child for this one, but usually it's a family member. If a family member had to maybe go part-time or stop working because they were taking care of their loved one, we can create this family caregiver agreement that will allow the older adult to pay their loved one for the care. And the way it works is, I mean, it's just like having, someone from the outside, a third party coming in. They would pay them hourly. The caregiver would keep track of everything that he or she is doing. They keep a log of all the things they're done, and they would get paid the going rate, which fair market value for the services they're providing. So if they're doing, grocery shopping, they're cleaning the house, they're helping with bathing and dressing, whatever it is, they would keep track of all of that, and then they could get paid appropriately for their time. However, that would be considered income taxable to the caregiver. So that would go on their income tax return. Another way that we can actually transfer to children would be if there's a transfer to a child with a disability or a child who's under the age of 21. You can transfer pretty much anything to those individuals, and it will not be considered a transfer for less than fair market value. You can also transfer real estate to a child who has been a caregiver for at least 2 years and living with the parent before the parent went into the facility. So for that, you actually have to get a doctor to sign off that if it wasn't for the child living with the parent for that time, the parent would have had to go into a facility much sooner. Then looking at another thing that could happen is that if a sibling was living with the person and they had an equity interest in the house and they lived there for at least 1 year before the person went into a facility, the property could be transferred to the sibling as well, and it would not be considered a transfer for less than fair market value. So there are things that can be done that will not be considered gifts. And as I talked about earlier with the Veterans Benefit Trust, you can do that type of pre-planning trust to try to get the veterans benefits earlier to help pay for care, like in a personal care home, like ecumenical. The VA benefit can actually provide, a significant amount of money if the person is a married veteran. Now, if we're talking more of an emergency situation, so we're already in a skilled nursing facility and we do not have a lot of pre-planning options here, which means we don't have the 5 years or 3 years for the various benefits. Then we're looking at what we call a spend down. So this is what happens when someone is already in the facility and we're trying to get them eligible for Medicaid. There are certain things that you're allowed to spend money on that will not be considered a gift, will not be considered, an issue when we are dealing with trying to become eligible for these benefits. So a big one that a lot of people do, I mean, this is something you need to do anyway, would be to prepay the funeral. There are two main options these are done in. You can create an irrevocable burial account. There are a few banks locally who provide those accounts. You have to specifically say which funeral home you want it to go to when you pass away. And you would put the certain amount of funds in there. And then when you pass, that account will be used to pay for your funeral. Now, the issue with that type of account is if there's any money left in it when you pass away, then it would go to your estate, which then would have to go back to the state of Pennsylvania to repay any benefits they paid. The other option would be to prepay the funeral through a funeral insurance policy. These are more helpful because you can add beneficiaries on them. So if there was any funeral refund after you pass away, then it would go to your loved ones instead of to your estate, which would then go back to the state of Pennsylvania, assuming you had been on Medicaid benefits. When prepaying the funeral, there is an average amount that you're allowed to spend on the funeral itself. And this is controlled by Medicaid. So they have a sheet that says for each county, how much the average funeral will cost, and that you really shouldn't go over. They have an average amount, and then they have the 25% additional amount on top of that. And you really shouldn't go over that. So if you were to prepay the funerals, then that would be, like I said, an allowed spend down item. Another thing that can be used for spend down would be if someone needed a new car. They can purchase a new vehicle, they could trade in the old one towards a new one and spend money towards it, and that's perfectly allowed. That's typically something that happens when we have a husband and a wife, and we're trying to spend down and we're thinking about what the wife might need if the husband is the one in the nursing home, and vice versa. You can pay off the mortgage on the house and any other debts and expenses. So these are just all, allowed spend down items. One other thing I want to point out about the funerals is that when you prepay the funeral, the amount you're allowed to spend is based off of where the funeral home is located. So if you're in a nursing home in Adams County, but you prepaid a funeral at a funeral home in Dauphin County, then it's the Dauphin County number that controls, not Adams County. That's just something for people to be aware of. And then you can also renovate the house. So like I said, this is a lot easier when you have kind of a husband-wife situation, and one spouse is in the nursing home and the other one is still home, but the house needs a lot of renovations for them to remain there. They can spend money on those renovations. So if you still have some money left over, there is a way to transfer those extra resources into income. So it's called a DRA, Deficit Reduction Act compliant Medicaid annuity, and you can see the requirements there. So it's not exactly a great investment. It's just something that you kind of do as a last resort if we're already dealing with the nursing home situation. This is not something that you'd want to do if you're just in personal care. This, like I said, this is something that you'd only do if you're already in the nursing home and kind of exhausted all the other options. So I just have a little case study here. So we have John, who's 75, and Sally, who's 70. They're married about 45 years. John was diagnosed with Parkinson's about 10 years ago, and he's now wheelchair bound. He cannot transfer from bed to a chair without at least 2 people helping him. So that's kind of a key thing there. If someone is a 2-person assist, typically they're going to have to be in a skilled nursing facility to deal with that. The doctor has signed a medical form declaring that he's NFCE, so he's nursing facility clinically eligible, so he has to go to the skilled nursing facility. So we have his income is $3,500 a month, and Sally's income is $900 a month. And this is not, out of the ordinary. We typically see people who, of the older generations now, maybe the spouse at home, if it's the wife now, who's in this case, Sally, her income might have been less than her husband's. So now he's going to the nursing home and she's worried she's going to lose everything. So they have a, 2015 Honda CRV. They have the residence worth $350,000 with a $100,000 mortgage. Her IRA, they have joint bank accounts. They have individual checking, which is her individual checking, his life insurance with a cash value of $30,000 and a death benefit of $100,000. So what can be done? We have automatically, we know, protected, right? So the car will be protected, her house will be protected, and her IRA will be protected. Now, with the car, like I said earlier, she could get a new car if she wanted, or she can keep that one. For the residents, we would probably transfer it into her name alone, just take his name off of there. And then for her IRA, it is protected, but we'd want to change the beneficiary. She probably had her husband named as the primary beneficiary, then we would want to change that to whomever she'd want next. Because if she would pass and he's on Medicaid and he inherits the IRA, that would kick him off his benefit. So items that are at risk, we call these those countable resources. So the joint bank accounts. Sally's checking. So this is something that a lot of people are surprised at. Even though it's in her name alone, it was a checking account. So that is considered available. The cash value of the life insurance, another surprising one. And then that takes our grand total to $380,000. So we know Sally gets to keep $133.80. John only gets to keep $2,400 because his income was on the higher end. So now we have to spend down $247,220. So she first, an easy one, we could pay off the mortgage. Okay, it takes us down to $147. Then we could prepay the funerals. So just kind of averaging the funerals in this area, we pay for both of them. So it'd be $32,000. Now we're down to the $115,220. So if she didn't want to buy a new car, she didn't want to put renovations against the house, she has this $115,220 left. So she could purchase that Deficit Reduction Act Medicaid annuity, and what that would do is it would be divided amongst a period of years. So in this case, I said she did it over 2 years. So that would pay her back as income $4,800 a month. So yes, she lost his income because his income has to go to the nursing home, but now we were able to turn those extra assets into income for her to make up for that she had lost his income for the next few years. I know I threw a lot at you here, so just open for any questions now if you have any questions.